Welcome to Part 7 of Sonoma County's 12-part Insurance Requirements for Contracts training program. In Part 7, we're going to discuss additional insured endorsements for general liability and subrogation waivers. So, the first thing that we want to know about additional insured endorsements is, what do they do? You know, we're always, every template says we've got to have additional insured endorsements. What does it actually do? It adds the county as an insured on the other guy's policy. Because imagine us contracting with another party and they have a naked policy, naked, no endorsements on it. Would we be covered by their policy? No, they're covered on their policy. So an additional insured endorsement changes the definition of insured, who's covered, to include us or whatever additional insured is endorsed on. So what does it do? It pays claims for the additional insured, just as it pays claims for the named insured and other insured parties. And it also, equally important, provides defense costs. Remember, defense costs are outside of the limits. It provides defense costs for insureds, and that includes us, the additional insured. Now, some key concepts. It doesn't increase the policy limits. It makes more insureds, but it doesn't increase the policy limits. And another concept that we're going to explore in just a minute is that insurance coverage for the additional insured is limited or restricted. It doesn't give the additional insured full run of the policy. And one thing I do want to mention before we go on, if you ever try to read some of these endorsements, it's really hard to figure out what they're saying. One of the confusions for us is the fact that these endorsements use the word you in them. Not all of them, but almost all of the companies. A named insured is the party who bought the policy, whose name is on the front, on the declarations page of the policy. Every time you get an additional insured endorsement and you're trying to read it to figure out, you know, is it giving us the right protection, it's real easy to think that, but this is going to sound weird, that you is us. You ain't us. You's the other guy. You is the party that bought the policy. Okay? So if you're trying to figure out what the endorsement says, every time it says you, it's talking about the party with whom we're contracting and not about us, the county. That's one of the things that makes it really difficult for us to review evidence of insurance, because we see you and we think it's referring to us, and it's not. Okay, so I want us to examine some of these concepts in a little more detail. As we said, the main thing that happens is that the definition of who's insured is changed to include the additional insured. All right, so let's just use an example. Any of you guys go to the county fair? Yeah, I love the Sonoma County Fair. Any of you guys go to Bubba's Bad Barbecue? Actually, it's Big Bubba's Bad Barbecue. Big Bubba's my favorite. All right, I go there. Okay, now think about what Big Bubba's is doing at the fair. They're not working for the fair. But what they are doing is they are operating there. They're paying the fair something for the privilege of operating there, and the fair has given them a license agreement, permission to operate on the fairgrounds. So what we want is, well, suppose Bubba's got some bad food and people get sick. Who are they going to insure? Who are they going to sue? Not only Bubba's, but the fair, right? Fair didn't do anything. So what we want is Bubba's insurance policy to cover Bubba and the fair if it gets named in a suit for bodily injury resulting from Bubba's bad food instead of Bubba's bad barbecue, right? There we go. Okay. Now, for the fair, the proper additional insured is actually Sonoma County Fair and Exposition and the Harvest Fair and the County of Sonoma. And the reasons for that don't matter, but it's on our webpage. So we need an endorsement that changes Bubba's insurance policy definition of insured to include those entities. As additional insureds, those entities are entitled to defense, and if those entities are deemed to be legally liable or responsible to the injured party, it would cover the damage that we owe them. All right, now, you're looking at the next slide, and she's going, what, are these guys eating Bubba's? No.
Getting ready to be Bubba's.
Getting ready to be, yeah, that's right. They're training to be Bubba's. Okay. My theory of limits in the general liability with respect to additional insured is that it's pigs at the trough. That's what the pigs are doing at the trough. Real simple. Farmer has a trough. The trough is 6 feet long, 2 feet wide, and 2 feet deep. And the farmer fills it with pig slop, right? So then pigs come and feed at the trough. Farmer only fills the trough once. Whether there are 2 pigs, 4 pigs, 8 pigs, 10 pigs, that's all the food in the trough. That's how it is with insurance limits. See, I told you, it's just like buckets and pigs at the trough. If an occurrence limit on Bubba's policy is $1 million, that $1 million has to go for Bubba's and the county fair and the county and the harvest fair and anybody else who's an additional insured. There's no extra limits. You make more additional insureds, you don't make more limits. The more additional insureds you have, the thinner the limits are going to be stretched amongst the additional insureds. That's why some attorneys tell you settle your claim fast before the limits run out. Okay, now the next concept, and this is really the heart of what we want to talk about here, is insurance, additional insured status comes in a box or in a cage. It's limited. You will never, ever see an endorsement that says the definition of insured is amended to include the county of Sonoma, period. It will always say the definition of insured is amended to include the county of Sonoma, but only with respect to, and it specifies a relationship. So we are not covered for everything. We are only covered for liability that comes to us because of the relationship. It is incredibly important that the additional insured endorsement we get reflect the relationship between us and the other party. Otherwise, we've got nothing. And I'd like to share some examples with you. This is one for the real estate people. In the real estate department, there are premises that you lease out, and you do a formal lease agreement, right? It says it's a lease. However, there are other premises that we give people permission to use, but they're not lease agreements. They're license agreements. And in fact, most county license agreements have a clause somewhere in them that says this is a lease, this is a license, not a lease. Okay, now there's an additional insured endorsement out there that says we're changing the definition of insured to include, and you fill in County of Sonoma, but only with respect to premises leased to you. Now remember, you is not us, that's the party that's leasing the premises. Only with respect to premises leased to you by the County of Sonoma. Well, what if we issued a license agreement? Our license agreement says it's not a lease. Technically, it doesn't match. Did you all follow that whole thing? Now, this might end up in court if we need that policy to cover us as an additional insured, as it ends up in court. And the court may say, well, that was the intention of the parties. But they might not. We don't want an additional insured endorsement that ends up in court, waiting for the judges to interpret it. We want an additional insured endorsement that satisfies the relationship so that the insurer knows that we are an additional insured and we are entitled to coverage. And it's all about the relationship. All right, another example. I got a lot of gray hairs out of this one. At the fair. I just love the fair. So, okay. Has any of you ever seen the mechanical bull at the fair? Pretty high risk, right? The contract that we sign for the mechanical bull is a license agreement. They're not doing work for us. What they're doing is we're giving them permission to run their ride and charge money on our premises, and then they pay us a rent or a fee, however the fair does it. So, from this company, we get an additional insured endorsement that says the fair and the Harvest Fair and the County of Sonoma and all those other folks have been endorsed as additional insureds, but only with respect to work that that's the mechanical bull company, right? We're not you, that's them, that you do for the additional insured. Are they doing work for us? Not under that contract. We didn't give them a contract, that we're not hiring them as a consultant or a contractor. We gave them a license agreement, which is permission to do the fair. Not good. Okay, are you starting to get the picture? Similarly, some of our departments issue permits. And there are additional insured endorsements that say who's an additional insured? County of Sonoma, but only with respect to permits issued to you, that's the party who got the permit, by the additional insured. That's great. But if we gave them a license agreement or some other permission that's not a permit, what have we got? All right? So the whole deal about additional insured endorsements is that they need to match the relationship that we have with the other party. And you might remember that when you send in a help request and you ask for risk management help in possibly vetting insurance requirements, we always ask for a copy of the contract and the scope of work. That's one of the reasons, so that we can figure out exactly what is the relationship between us and the party with whom we're contracting. You've heard the old expression, it's apples and oranges. No substitutions in additional insured endorsements. Do you ever try and make an apple pie and substitute oranges for apples? Your Thanksgiving guests will not appreciate that. They are not interchangeable. They must fit the situation, the relationship. I'll give you another example. county issued a license agreement to the Sonoma Valley vintners, and essentially they were using our premises as a parking area for an event. That's all that was happening, and the people were going somewhere else, but they were busing the people up to the event, but they were using our parking area to have this event. We issued them a license agreement. They are a not-for-profit, and they're insured with the Not-for-Profits Alliance, which has some strange additional insured endorsements. Now, remember what we did? We gave them a license agreement to allow people to park on our premises, right, for an event. So we get this endorsement from the Not-for-Profit Nonprofits Alliance insurer that says that we're additional insureds. For what? For liability of organizations contributing food or referring clients. Excuse me? Couldn't accept that because we were not contributing food to the vendors and we weren't referring clients to them. So you've got no apples and oranges here, no substitutions. You've got to have an additional insured endorsement that matches the relationship with the other party. Endorsements that have no fill-in, no fill-ins. There's no place to fill in the policy number, and there's no place for the date. Unfortunately, there's nothing we can do about that. And the reason for that is the way insurers issue policies. You can either fill it in on the endorsement, or what the other thing they can do is on the policy declarations, the face page, they can put an indication that that endorsement is attached to the policy. So you don't get that on the endorsement. And there's nothing we can do about it. I suppose we could require a copy of the declarations page with it, but you remember the drowning in paperwork stuff? You would have a real nightmare. So, and for that matter, if somebody wanted to be less than honest, you can get a sample copy of an endorsement. I mean, it's on the internet. It's really easy to get a blank endorsement. I can go type in a name and a policy number at the top, and you never know. So it's not worth the extra time to deal with that, and we know it's a problem. Okay, sometimes in our templates we just specify the relationship. So for example, construction templates might say we want to be additional insureds for ongoing and completed operations. Some other templates may actually specify an endorsement number. But be clear, when we specify an endorsement number, we always say or equivalent. We can't force the companies to use exactly these. So this is an example from template 11, which is license agreements. The language we want, and we're going to talk about what these endorsements are in just a minute. We want endorsement CZ 2026, and I've underlined for you or equivalent, because we understand that some companies may have an endorsement that says the same thing, but it doesn't have that number. We also point out when it comes to additional insureds, in your template assistance, real helpful information is in the help text. For example, in this template, we point out that we won't accept the CG 2010, which we're going to learn in just a minute, is work performed for the additional insured, because we're talking about license agreements here. So really use your template assistant for help in vetting and reviewing additional insured endorsements. Now, we have available sample additional insured endorsements, and you can get to them by clicking the link from our navigation page. Additionally, in the template assistance, there are links to these sample additional insured endorsements. What do you have on the samples? In addition to the sample language, we have helpful notes, explanations. We've highlighted the important language so that you know what kind of language to look for if you get a different endorsement that would be equivalent. And we give instructions on what we can accept. So those are really, really helpful. What we want to do now is talk about several of the most common additional insured endorsements that we see. And the first one we're going to talk about is the CG 2010. The title of this is Owners, Lessees, or Contractors. Please don't ask me where the insurance industry got that name. I don't know. They didn't ask me to name it. If they did, I would have given them some better suggestions. All right. Remember from our prior training part, we talked about ongoing operations. Okay. This is an additional insured endorsement that has two components in it. We're going to be additional insureds for liability arising out of ongoing operations. Once the work is done, kaput, finished. And the work has to be performed for us, the additional insured. Those are the two, and you can see that. We've highlighted the language. So we want a CG 2010 or equivalent from anyone doing work for us. That could be a contractor. It could also even be a consultant, because it is very possible that, not likely, but it's possible that a consultant doing work for us could injure a member of the public. That, again, that's kind of low risk, but that would be a CG 2010, doing work for us while the work is ongoing. I repeat, because this happens all the time, we cannot accept this if the party with whom we're contracting is not doing work for us, right? Because this is limited to giving us additional insured status because of work the other party is doing for us. Now, we've said we don't need this very endorsement. We could take any endorsement that has equivalent or similar language. Now, you'll notice that the left-hand box requires that you fill in the name of the additional insured party. That's us. And the right-hand box wants a description of covered operations. The starting out position is you must fill in both fields. If the fields are left blank, I'm going to amend this in a minute, but the starting out position is you must complete both boxes or we're not playing with a full deck. One word of caution. The right-hand box, location of covered operations, if you're talking about a contractor, that's not your office, unless they are remodeling your office. But if you have hired a contractor to do work somewhere else, we want the job location. And you could put all kinds of things, like you could put work as specified under contract 42376. That would work. But what you don't want is your office there unless they're doing the work at the office. Now, the question that was asked before, and this is the time to answer this, is the by contract. Some carriers, we call this blanket. The carrier simply says if their insured needs to provide additional insured endorsements because of contracts, we will deem it to be so. So on this endorsement, on the left-hand side, they would write something like as required by contract or some similar language that, or if required by contract, that's perfectly acceptable because we require it in all our contracts. So if you, and then they don't have to fill in the right-hand box. So if you get an endorsement where the field is filled in with by contract language, that is perfectly acceptable to the County of Sonoma. If we get a certificate where the fields are blank, but the information from the fields is on the certificate, can we accept that? What do you think? No, because we don't accept, what do they use in nuclear agreements? Trust but verify? Isn't that the terminology? No, it must be here. The only other place you could have it, potentially, is in the policy declarations, but not on the certificate. We were talking in an earlier training session about not relying on the certificate, and we want to see the endorsement. Besides verifying the presence of the endorsement, we want to verify that it's the right endorsement, the right relationship, whether it's apples or oranges. So you could get a certificate that said we were endorsed as additional insurance. In fact, we were. The only trouble is they sent you the wrong endorsement. You can't use the work performed for when someone's renting a vet's hall. So we're going to tie this all together. No, you cannot rely on the certificate. You need to have the endorsement done. Okay, the companion endorsement for contracting and construction is the additional insured, what I call additional insured completed operations. It's that same title, owners, lessees, or contractors. This one is for completed operations. This one makes us an additional insured for liability or injury or damage arising from the contractor's completed operations after the work is done. Remember, Sparky's. Sparky's finished the wiring job, and 6 months later there's a fire causing injury or damage. That's a completed operations exposure to Sparky's. Now, remember always that the injury or damage has to occur during the policy period. Well, the policy that Sparky's had when they did the work might have expired, so we might want it on the next policy for another year. So, for construction and contracting risks, people doing physical type work, we essentially want 2 additional insured endorsements. One that gives us additional insured status for ongoing operations. One that gives us additional insured status for completed operations. It takes 2 to tango. See, the insurance industry, why issue 1 endorsement when they can issue 2, right? They love paper. Again, equivalent language is acceptable. We don't need this endorsement. The fields must be filled in, and the same issue, the location cannot be your office, and we will accept the by contract language as required by contract. That's perfectly acceptable. There are some insurers who write their own additional insured endorsements for construction where they combine the ongoing and completed operations in one endorsement. That would be proprietary, and there could be all kinds of versions of that. That would be acceptable if they did that. And if you got one like that and you were not sure that it was compliant, that would be something you could, for which you could send a help request and have risk management review it. Okay, so those are our 2 basic construction additional insureds. Now we're going to get into some premises things. The CG 2011 is for leased premises. That's L-E-A-S-E-D, not L-E-A-S-T, because we never have leased premises. Ours are the most premises. Okay, anyway, you feel this one, notice the highlighted language where additional insureds for liability arising out of premises leased to you, you being our tenant, right? We're not you, the tenant, the other guy's the you. Okay, if there's no lease, you cannot accept this. Okay, that's a very rigid, hardline approach. If you have a license agreement, you should not accept this. And we'll tell you what to use for license agreements. That's coming. The locations need to be filled in. If the top of this has that by contract language, that's perfectly acceptable. That's fine. Okay, this is a sample general liability subrogation waiver. And again, the blank has to be filled in. If you get a blank piece of paper, you don't have very much. And if they've written in by contract, as required by contract, that is acceptable. If we haven't required it in that particular template, it's not required, so they're not going to send it to you. But for the templates where we require it, it's in the contract, so that would take care of us. Did that all make sense? Oh, good. All right. Why would the county require that folks who rent our veterans halls and other facilities to have events, why would we require them to have liability insurance and to make us additional insured status, or give us additional insured status? Well, the simple answer is it gives us two benefits. The first benefit is that if we are named in a suit, even if the suit is frivolous, even if we're really not liable, we need defense costs. And by being added as an additional insured onto our renter's liability policy, the carrier is obligated to provide a defense for us if we are named in a covered suit. Defense costs can be very expensive. Sometimes no damages are awarded, but we run up $40,000, $50,000, $60,000, $70,000, $100,000 defending the case, and that should be paid by the insurer of the party who rents the hall. And should we be all or partially responsible for the injuries to people, then we want our renter's liability policy to pay that part of the damage for which we are liable. And that's the reason that we require additional insured status on their liability policy. Okay, I love this endorsement, the CG 2026. It's called Additional Insured Designated Person or Organization. This is the catch-all additional insured endorsement. It works for almost everything except completed operations or products. In other words, people who get hurt from a product that somebody else manufactured and we give out or distribute, or the completed operations exposure. You remember Sparky's, right? And the injury or damage that happens after Sparky's completed the job. This won't deal with that. It excludes completed operation hazard. So what could you use this for? You could use it for a consultant doing work for us. It doesn't say doing work for us, but it doesn't eliminate it. It's that broad. You could use it for someone leasing premises from us. You probably wouldn't get it in that situation, but you could. You would get it for someone who has a license agreement to do things on our premises. It works for someone who has a permit. It works for easements. It works for almost anything except the product's completed operations hazard exposure that we talked about earlier. This is a great piece of paper. Oh yeah, it works for grant agreements too. Same principles. The fields need to be completed, and if they wrote in as required by contract, that would be perfectly acceptable to the county. Now, we have been dancing around, several of you have asked questions about the primary and non-contributory. Not only do we want the other guy's insurance to cover us, we want their insurance to come first for us. Think about our position. As the county, we have insurance in a risk-sharing pool, the CSAC EIA. That insurance has a $1 million retention. Without going into great detail, that means we are responsible for the first $1 million of every claim. So, we don't want to touch our $1 million retention, thank you very much. Nor do we want to dig into our CSAC coverage. So, essentially, what we want is when they make us an additional insured on their policy, we want it to be primary and non-contributory. And essentially what that means is we would then be covered on their policy and our own insurance with that $1 million in the middle. So we want their policy to defend us and pay any damages that we owe stemming from the relationship of the additional insured endorsement till the buckets are empty, until the limits are exhausted. Then we get into our own coverage. We do not want to touch our own coverage till we've sucked every dollar out of their coverage. Now, how do you know about primary and non-contributory? Well, all right, so first of all, I want to mention, and I think I may have said it before, in most templates, it's required in all templates, but we only require documentation in certain templates. The documentation is required in construction templates and any template involving our marinas or the airport. Many times what you'll get is an endorsement that kind of looks like this, which essentially says that the coverage for the additional insured is primary and non-contributory, and it will usually say if it's required in the contract. Well, it's required in all our contracts, so we don't have to worry. However, I also want to point out that some insurers don't use an endorsement. For this, some insurers reword the additional insured endorsement to build in primary and non-contributory language right in the endorsement. That would be acceptable as well. Okay, the last thing that we want to tackle in this training part is a discussion of general liability subrogation waivers. Well, in order to talk about a subrogation waiver, we got to first talk about subrogation, because it doesn't make any sense to waive it if we don't know what it is we're waiving. Okay, has any of you ever heard of the term subrogation? Yeah, what does subrogation mean? Oh yeah, one of those words, right? The insurance company pays and then they go after you. And sometimes instead of subrogation, the terminology is called transfer of recovery rights. The basic concept is when the claim is covered by policy, the insurer is going to go out and pay the claim. But if some other party is contributed to the injury, is negligent in some way or partially, it doesn't have to be completely, the insurance company retains the right or gets the right to go after that party to recover all or part of its claim payment. Okay. Not us. When we contract with other parties, we do not want the insurer to have a right to come after us, even if we are partially responsible for the claim that they paid. So a subrogation, this is not a waiver we issue, this is a waiver that the carrier issues, they relinquish their right to come after us. So let's use an example, and this is a good one because we're getting near lunchtime, right? In the main building at 575, on the other side of the building, there's the SoCo Coffee, right? Okay. SoCo Coffee, oh, you just told me it's a license, it's an operating agreement. It's neither a license or a lease. Okay, so we give them an agreement to operate there. If some member of the public walks in there to buy something, because people from the public come in all the time, and they get hurt in the cafe, they will sue the cafe, SoCo, and so the SoCo's insurer will pay the claim. However, supposing it was a slip and fall, and supposing the insurer says, oh, wait a minute, county owns this space, the floor has bumps in it, the floor, or the county's janitorial service cleaned it up and they left water on the floor. Or, in other words, you see what I'm saying? The county was at least partially responsible. So SoCo's carrier pays the claim to the injured party, and let's just say they paid a $75,000 claim. They're going to turn around and say, you know what, County of Sonoma? We think your maintenance of this premises contributed halfway to this claim, so we want you to pay us back the other half of the claim. When SoCo's carrier waives its subrogation or recovery right, then they're stuck with it. They pay the whole thing, and even if we had some liability, they cannot come after us. Now, many carriers charge for waivers of subrogation, and so in most templates for general liability, we do not require it. We do require it in all of our construction templates, and we require it in leases. And there are certain areas where we do require a waiver of subrogation in general liability. We are also aware that it costs. The carrier will charge something in many cases to issue a waiver of subrogation. So that's why we're judicious in requiring it and try not to require it in things that probably have a pretty low risk. Do check your template assistance, because if it is required, some of the templates allow for a department waiver of a general liability subrogation waiver, and other ones do not, but you can submit a request to risk management and get a risk management waiver. And you won't get a waiver in construction contracts. We don't waive anything in construction contracts. Why is it required to be an additional insured when we give a license agreement for the use of a vet's hall? Okay, supposing somebody's having an event and there's all kinds of stuff around the room and it's dangerous, or they've wired up some equipment and we didn't wire it up. You know, they ran a wire right down the middle of the room, and somebody.
Stuff, not our stuff.
It's nothing we did. They did something, and then a member of the public, or one of the attendees at the event, got hurt. We don't want to use our own insurance for something like that, and that's the reason for that. This concludes Part 7 of Sonoma County's insurance training.